6 a.m., Sunday morning. You're drinking your coffee in your kitchen. There's a loud knock on your front door. You open it, and standing there are two federal agents in tactical vests. One of them holds up a clipboard and says, "We have records showing you purchased multiple firearms. We need to confirm you still have them. Let us in." Your stomach drops. Your mind races. You think, do they have a warrant? Am I in trouble? Do I have to show them my guns? Here's what nobody tells you. In that moment, your answer, those next few words out of your mouth, will determine whether you keep your constitutional rights or hand them away for free. Today, I'm breaking down exactly what the law says and exactly what you should do when law enforcement demands to see your firearms. We're covering two scenarios: when they show up at your home and when it happens during a traffic stop. And I promise you, what you're about to learn could save you from making the worst mistake of your life. Now, before we dive in, you need to understand something. This is not some hypothetical scenario I made up. This is happening across America right now. There are documented cases, real cases on camera, of federal agents knocking on doors of law-abiding citizens, demanding to inspect their legally purchased firearms. No warrant, no probable cause, just a clipboard and an attitude. And the worst part? Most people don't know their rights, so they just open the door. They let them in, they show everything. And in doing so, they give up protections that took 200 years to build. So let's make sure that never happens to you. All right, scenario 1. Law enforcement shows up at your front door. They claim they have records of your firearm purchases. They want to come inside and verify. Now, the first thing you need to understand is that federal law draws a clear line between two categories of firearms. On one side, you have weapons regulated under the National Firearms Act. We're talking short-barreled rifles, short-barreled shotguns, suppressors, fully automatic weapons, and certain destructive devices. These require special registration and federal tax stamps. On the other side, you have standard firearms, your handguns, your rifles, your shotguns, your AR platform weapons, the vast majority of what Americans own. Now here's the critical point. For standard firearms, the ones most of you own, federal agents have absolutely zero authority to show up at your home and demand to see them. None. Period. There is no law, no regulation, no executive order that gives them that power. But what about the more heavily regulated ones? The machine guns, the suppressors. If you went through the federal registration process, filled out your paperwork, paid your tax stamp, waited months for approval, surely that gives them the right to inspect? Here's what most people get wrong about this. When you filled out those federal forms, your Form 1, your Form 4, go back and read them carefully. Nowhere, and I mean nowhere on those documents, did you sign away your Fourth Amendment rights. Let me say that again, because it's that important. Owning a registered firearm, any firearm, whether it's a standard handgun or a registered machine gun, does not create an exception to your constitutional protection against unreasonable searches. You did not agree to random inspections. You did not consent to unannounced visits. That waiver does not exist. So what do you actually do when there's that knock on your door? Step 1, and this is the most important thing I will say in this entire video, do not open the door. You are under no legal obligation to answer. You are under no legal obligation to speak to them through the door. You don't have to acknowledge they're there. And here's why this matters so much. The moment you crack open that door, you activate something called the plain view doctrine. That means anything an officer can see from your doorway, anything visible behind you, on your walls, on your table, becomes fair game. If they spot something they consider suspicious, that could give them probable cause to enter your entire home without a warrant. You open the door to be polite. You end up with agents searching your house. Step 2. Understand the only situations where they can legally enter. There are exactly 4 ways law enforcement can get through your front door. 1, you give them consent, which you should never do. 2, they present a valid search warrant, signed by a judge with a supporting affidavit establishing probable cause. 3, they have a valid arrest warrant with your name on it. 4, exigent circumstances. That means they have reason to believe evidence is being destroyed right now, or someone is in immediate physical danger inside. That's it. 4 ways. Nothing else. And here's the tell. If they actually had a warrant, they wouldn't be knocking and asking nicely. They'd already be inside. Now, let me warn you about something. Because agents are trained to use pressure, and they're very good at it. Here's what it sounds like. They'll say something like, "Look, we can do this the easy way or the hard way. Just show me the firearms now, and we won't have to go get a warrant and come back to tear through your entire house." Sounds intimidating, right? It's designed to be. That's the whole point. But let's break down what they're actually saying. They're admitting, right there in that sentence, that they do not have a warrant. They don't have probable cause. They have nothing. They're hoping you'll get scared enough to consent. And if you do, you just gave up every protection you had, voluntarily, for free. So when you hear that threat, and it is a threat, recognize it for what it is, a negotiation tactic from someone who has no legal authority to do what they're trying to do. Now, what if they actually do claim to have a warrant? Here's what you do. You ask them through the closed door to slide the warrant underneath. You have every legal right to review that document before you open the door. This is not optional for them. They are required to present it to you. Once you review it, if it is a valid warrant, yes, you open the door, you comply. But even then, you are not helpless. You say 2 things. I exercise my right to remain silent. And then, I do not consent to any search of any item, person, or area not specifically listed in this warrant. And then, you stop talking. Completely. Because that warrant has limits. It specifies exactly what they can search and where. Anything beyond that scope, your attorney can challenge it, but only if you clearly stated you did not consent. All right, scenario 2, and this is the one that happens far more often. You're driving home. Maybe you changed lanes without signaling. Maybe you were going 7 over the limit. An officer pulls you over. Routine stuff. Should take 5 minutes. But then the officer walks up to your window and says, "Are there any weapons in this vehicle? I need you to hand them over." What do? Can you refuse? Do you have to tell them? Let's walk through this step by step. Before we get into the legal strategy, let's cover the fundamentals. Because I've seen too many videos where someone had every legal right on their side and they still ended up in handcuffs because of how they handled the first 30 seconds. The moment those lights go on behind you and you pull over, hands go on the steering wheel. Both of them. And they stay there until the officer tells you otherwise. Do not reach for your glove box. Do not dig around in your center console. Do not reach under your seat. I don't care if you're looking for your registration. Because here's what happens. The officer is walking toward your car, and from their perspective, all they see is someone making sudden movements below the window line. Every time, the officer will document that as suspicious behavior. And those movements alone can give them legal grounds to pull you out of the car and search you for weapons. So keep your hands visible. Wait for instructions. When you do need to reach for something, narrate it. "Officer, my registration is in the glove compartment. I'm going to reach for it now." Beyond that, provide what the law requires. In most states, that's your driver's license and proof of insurance. Some states require your registration, though officers usually run that from their vehicle. Hand it over, and then keep your mouth shut. Now, here's where most people destroy their own case without realizing it. The officer walks up and starts asking questions, and these questions are designed, carefully designed, to sound like casual conversation, but they're not. They're interrogation techniques. "So, where are you headed tonight? You seem a little nervous. Everything okay? Do you know how fast you were going back there? Every single one of these is designed to get you talking, because the more you talk, the more ammunition you give them. And some of these questions are what I call rhetorical traps. The officer says something like, "You know you were going pretty fast back there, right?" If you say yes, you just confessed. If you say no, now you're being dishonest. There is no good answer. Except one. "Officer, I respectfully exercise my right to remain silent." Done. That's it. You're not being rude. You're not escalating. You're exercising a constitutional right that exists for this exact moment. Now let's get to the big one. The officer finds nothing on you. So now comes the question, and pay attention to how it's phrased. "You don't mind if I take a look in your car, do you?" Notice that. It's not even framed as a question. It's framed as a statement, as if saying yes is just a formality. And here's the dangerous part. There are actual court cases, real rulings, where judges have said that if someone stays silent when asked for consent to search, the officer can argue that silence was consent, that by not objecting, you impliedly agreed. So this is one of the rare situations where silence is not enough. You must speak up. You must say it clearly. "Officer, I do not consent to a search of my vehicle." One sentence. Say it once, say it clearly, and then go back to being silent. Now, what happens next? I'll tell you exactly what happens because I've watched hundreds of these encounters. The officer will try to guilt you. "Come on, if you've got nothing to hide, why won't you let me look? I thought we were having a nice conversation here. Why are you making this difficult?" An innocent person wouldn't have a problem with this. Every single one of these is a pressure technique. They're trained to say this. It's in their playbook. And it works, because most people cave. But here's what you need to understand. Your refusal to consent to a search cannot be used against you in court. It is not evidence of guilt. It is the exercise of a right that the Fourth Amendment guarantees to every single person in this country. And if you do consent, you've just given that officer unlimited authority to spend the next hour tearing your vehicle apart. I've seen seats removed. I've seen personal belongings thrown on the pavement. I've seen glove boxes emptied onto the ground. All because someone said the word sure. Here's the next critical step, and almost nobody does this. If the officer keeps holding you on the side of the road, keeps asking questions, keeps trying different angles, at some point you need to ask, "Officer, am I free to leave?" This question matters enormously because under Supreme Court precedent, a traffic stop is only supposed to last as long as reasonably necessary for the original purpose. If you were stopped for speeding, they write the ticket and you go. They are not supposed to hold you for 45 minutes fishing for something else. If the officer says yes, you're free to go, leave, slowly, safely, end the encounter. If the officer says no, then you are being detained, and at that point, you escalate your rights. You say, "I understand. I exercise my right to remain silent, and I am requesting an attorney." And then, complete silence. Not another word. And that brings me to the misconception that trips up more people than anything else. A lot of people think, I'll just wait until they read me my Miranda rights. Then I'll ask for a lawyer. Here's the problem with that plan. Police are not required to read you your Miranda rights during a traffic stop. They're not required to read them during a detention. Miranda only kicks in during what's called a custodial interrogation, meaning you're in custody and they're questioning you. And here's the trick. If they never ask you a direct question after the arrest, they never have to read Miranda at all. They'll just use everything you volunteered before the arrest. So if you're sitting on the side of the road saying, "But they haven't read me my rights yet," you're waiting for something that may never come. And while you're waiting, you're talking. And while you're talking, you're building their case for them. Don't wait for permission to exercise your rights. Your rights are already active. They've been active since the moment those lights went on behind you. So let's bring it all together. Can law enforcement demand to see your guns at your home? No, not without a warrant, an arrest warrant, or a genuine emergency. And you don't have to open the door. Can they demand your firearms during a traffic stop? No, not unless you give consent or unless your own behavior gives them a legal opening. The formula is simple, and it works every single time. Keep your hands visible, stay calm, provide your documents. Do not consent to searches. Exercise your right to silence. Ask if you're free to go. Request an attorney the moment things escalate. That's it. 7 steps. Memorize them. Now, if you want to know what happens when police search your car without your consent and how to fight that in court, I break down the exact process in this video right here. I'll see you there.